Good afternoon, everyone. Thank you for joining us today for this session in the SPARK webinar series. My name is Kamran Tariq. I am the program manager for SPARK Hub. We are a BARDA Accelerator Network hub led by Children's National Hospital, focused on advancing medical countermeasures for pediatric populations. Before we begin, just a few quick housekeeping notes. This webinar is being recorded, but we will stop recording for the Q&A session, so please do not hesitate to ask any questions. If you have any questions at any point during the talk, feel free to drop them in the chat. You can also use the raise hand function if you'd like to ask a question directly, and we'll call on you. With that, I'll hand it over to our speakers for today.
Hello, everyone. My name is James Love. I'm a partner at Oblon. I've been doing patent law for about 20 years, and I'm joined today by Scott Lee, who is another one of our great professionals at Oblon. He also has a lot of experience in this area, and I'll just start this conversation by saying that this is a basics of IP type of presentation, so there may be things that you've heard before, but we like to try to make sure that we cover everything just in case some folks on the call aren't fully familiar with all types of IP. So I start as an overview of what we're going to look at today, which is specifically a couple of different types of IP, just to give people a sense. Then we'll kind of focus a little bit on patents, because I think patents are often what are the most important thing to look at in this type of situation. We'll go into little details about the process and the timeline and some reasons to why you might want to file a patent. Finally, we'll talk about some specific examples of types of patents and why it may be useful to you in this medical area. All right, so if we start at a very high level, there's really a few high-level parts of the intellectual property or types of intellectual property. First, of course, is patents, which I mentioned, and there are actually some breakdowns in these type of patents. And then we have copyrights. Copyrights are more protecting actual, for example, written materials or code for programs. Trade secrets are kind of related to patents in a lot of ways, but they aren't something that you actually share, because as we look at patents, we'll see that patents are a trade-off between actually releasing something to the public. So the public has to know what you've done and how you've done it, and in exchange, you get a monopoly. Trade secrets don't have this. You keep that monopoly to yourself, but there are some rules about trade secrets and how you have to behave in order to keep things as trade secrets. Oftentimes, people will ask, should I do a patent or a trade secret? It really depends, and as we get into the question portion of this, there could be situations where you might want to ask those questions. But high level, generally, patents are you feel comfortable releasing this to the public in exchange for that monopoly. Trade secrets is something you would keep to yourself and allow you to. Sometimes, if we think about, for example, software can be really good for trade secrets because you might not be able to reverse engineer it. However, if you could reverse engineer how it's done, maybe a patent is a better way to protect that information. We also have trademarks here, because trademarks is also another important kind of type of intellectual property, but this is more going to be protecting, for example, names and things of that regard. So we won't get into too much detail about that. I have a nice chart here which actually kind of gives examples of each one of these types of things. So utility patents, for example, you might want to protect a process for manipulating genetic traits, right? Or the iPod, or pieces of the iPhone, or chemical fertilizers. Design patents, which is another type of patent, that would actually be actually releasing or protecting specific shapes, right, of your material, or maybe of your design. It says a guitar here or a lamp. But remember that design patents are non-functional, right? So you can't get a design patent on a functional aspect of what you're trying to do. That would be a utility patent. Now, copyrights, of course, a lot of us know that photos, music, books, these are going to be copyrighted, but there also are ways to copyright computer programs to stop someone from copying exactly the type of thing that you've done. These examples here talk about music and artwork, right? So, but you see also the example of the Windows operating system. So, a lot of times people don't think about copyright as a good option for when you have software, but we'll talk about when we get into a little detail about about utility patents, how there's some difficulties in patenting some types of software, which may make copyright a better option for that type of situation. Now, we talked about trade secrets before. Some famous ones, of course, is the Coca-Cola formula. That's been a trade secret for many, many years. And they spent a lot of effort on making sure that's not shared with the world. So they didn't patent that. They didn't let everyone know how it's made. And of course, that's worked out for them because they were able to keep that trade secret for potentially indefinitely. Whereas a patent, of course, has a limited, as you can see here, 20 years from the date of the filing. Trademark, of course, as I mentioned, words, symbols, logos. If we go back to the Coca-Cola example, the name and the logo could be protected by trademark. All right, now that we get this high level, let's jump a little bit specifically into patents. And patents come from the Constitution. They are in the Constitution of the United States, which is, I think, pretty interesting. Right there, it says Congress shall have the power to promote the progress of science and useful arts, right? So by providing patents. So this is a government document that grants rights to inventors. It's this exchange with the government, exchange with the population, in effect, that you describe your invention in a way that someone can make and use it, and in exchange you get a monopoly. And now it's important to note and kind of remember that a U.S. patent is only enforceable in the U.S. So if you have this great invention, it's amazing, and you file a patent in the U.S. and you're granted this patent, you can stop people from making this product in the U.S. or maybe importing it into the U.S. But if you go to Canada and there's no patent in Canada, they can be free to use it as much as you want. Now, that's something you always need to think about because remember, you're putting out the how to make and use this invention to the whole public. And in exchange for that, you get that monopoly in the US, but not necessarily in other countries. So we'll talk a little bit about how you could protect yourself in those countries, but it is good to remember that a US patent is only enforceable in the US. So because a patent is intellectual property, right? It's intangible property, you can actually sell or assign these rights, right? You can license them, you can enforce them with a patent lawsuit. But remember, it is, rights. You can potentially mortgage your patent because if it has some value. Of course, patents, as we mentioned, are different from trademarks because they are actually protecting an invention, whereas these different trademarks, would identify the source of goods or protect, for example, something about the good that you indicate, like the brand name. Copyrights we talked about, but remember that even though these are different, there can be overlapping coverage. So you might have an invention and you're going to get a copyright on it for your software. You might also get a patent on portions of the software, and you might actually keep portions of the software as a trade secret. All right, so let's talk about different types of patent applications. So we have a provisional application, a utility, a PCT, and then we have foreign applications, as I mentioned before, and design applications. If I kind of break into what this provisional application is, you might say, well, what is the difference between a provisional and a utility application? So the provisional application is, in effect, I like to think of as an option to file a utility patent application. It's often much cheaper to file a provisional application, and you'll see why, because there's a lot less requirements when filing a provisional application. It's a lot more flexible. And oftentimes we will recommend people file provisional patent applications before they go into the expense of filing a regular utility application. And that's why you'll often hear people mention, I have a provisional application or I filed a provisional application. It's because it gives you that option to file a utility patent. I like to think of it as the line in the sand, right? So you have an invention, you say, okay, well, I need to make a line in the sand. I need something filed with an official government agency that indicates I invented this, but I don't want to spend all the effort on the utility patent. Well, the provisional provides you this 1 year before you actually have to file a utility application, and your option expires. Now, there's some benefits to it, right? One, that it's a patent pending status. So once you file that provisional application, you can feel comfortable and say, okay, well, I'm going to go and talk to potential licensees. I can talk to different people because I feel protected because I have this option to file a utility patent that's in the sand and filed with the patent office. It's not actually examined by a patent examiner. Instead, the examination happens after you convert this provisional application into a utility after that 1 year. Now, it can be done earlier. You can file a provisional, and then 6 months later, you can file a utility. But most people like to wait that entire year before filing the utility. All you need to get that filing date, that line in the sand, is specification and drawings, right? You just need, those limited things. Now, utility has a lot of details that you have to actually do. You have a specific form you have to write in. There has to be certain sections. These are not required at all for a provisional application. In fact, you don't even need claims to file a provisional application, although you'll see in a moment why we actually do recommend that you do that. It's not required. A provisional application could be as generic as PowerPoint presentation, right? You could just take your PowerPoint and put it into a provisional application. Now, there are reasons why this might not be a good idea, because if you do that, you potentially could be limiting yourself on your utility, what you're providing for support. But the point is that it's still permitted. Provisional application can be that flexible. It could even be hand drawings. That's another thing I like to mention to applicants is that you want to file a provisional application. You don't have spend the money on professional drawings for something. You could draw things out by hand and then just have them scanned in for your provisional application. The drawings actually be really helpful a lot of times. A lot of people don't think about it. They think about a write-up, and I know a lot of medical professionals are used to doing a lot of write-ups, right? Because you get published a lot. So this is something that's you're comfortable with, and you can use that often as the basis for your provisional application. But it's also good a lot of times to add some drawings. So add further kind of description. And you ask, well, why would I do that? And that's because drawings can provide support later on when you're doing your application. You have to, that's required, as I mentioned, but there's no required format. So you can make the drawings as flexible as you want. And oftentimes I'll see from, journal articles, just maybe one or two figures. But if you're talking about like a medical device or software, putting extra drawings can be actually very helpful. Okay, so I mentioned claims before. If you're not familiar, a normal application would have something called the specification, which is the write-up portion. It would have the drawings, which are drawings that are corresponding to the write-up portion, and then you'd have claims. The claims are actually what we like to think the metes and bounds of your invention. This is how you define and what your coverage of your invention is the claims. Now, when we're talking about a provisional application, they're not required to be included. However, it's a good idea because if you're going to rely upon this provisional for example, in foreign priority or even in the US, it's really a good idea to have such claims. So the best idea is to have at least one claim written up that kind of high level describes your invention. Now, people always like to ask me, can AI write my application for me? And one of the answers I always like to say is that AI is very poor at writing claims. Claims are very hard to do for AI, and you'll see even if AI can write you up a nice 50-page, description about your invention, it's really not going to be able to write you great and useful claims. So it's just be wary of that. I know this is kind of a side note from what I'm commenting here, but claims are actually a really important part of an application, and it's something that AI has a really hard time doing. And it is something that you really should be focusing on when you're writing your application, especially your utility application. And it's also useful to put it in your provisional. I'm going to jump to what the utility application. So I mentioned that a couple times when I was talking about the provisional. So this is actually what is examined by the U.S. Patent Office. It protects the functionality of the invention and has a lot of formal requirements. So you have a utility application, and oftentimes it's going to be something that, you look up an application, a patent application, for example, maybe in Google Patents, and you'll say, this is crazy. This looks like Greek to me. And the reason is because utility applications have a very specific way they need to be written, right? And it's not necessarily, when you're reading it, very easy to read, but it is the way that patents have, moved over the years, and it's actually very important. If you don't follow these specific formality requirements, you'll get a rejection from the patent office. And again, I like just to focus on claims because the claims are what define their invention. I remember there's a famous older judge that said the name of the game is the claim. So when you're looking at a patent application, you need to think about the claims. And again, I mentioned this earlier, but remember, it's 20 years from the original filing date is going to be the length of your patent. And, for a lot of software patents, that probably doesn't matter too much. 20 years from now, you can imagine software is going to be very different. But where it really matters is in the pharmaceutical area, right? Because there's so much testing that's required that 20 years is really important. And in a next lecture we give sometime, we can talk about how, there's some extension that goes to that time because it matters so much. Even a day can matter a lot for utility patents. Okay, so I mentioned about US applications, and then you might think, okay, well, what do I do if I want to protect my application in a lot of countries, and I don't only want it to be protected in the US? Well, there's something called a PCT application. So you heard earlier I mentioned about a provisional application that's a holding application. It keeps you and gives you rights in the US after that year. Well, there's something called a PCT application, which is almost effectively the same thing. It's an international holding application. It preserves your rights internationally in all the PCT countries, which there's more, so most countries in the world are PCT treaty countries. So just like the provisional, you must file 1 year from the first national filing date. So if you want to file, for example, you file a provisional, you have 1 year to file a utility. Well, you also have 1 year to file your PCT application. And if you start with the utility, you don't file a provisional, you have 1 year from that utility filing to file your PCT application. And what's useful for this is that it gives you additional time. So you filed your provisional, 1 year later, you filed your PCT application, you still have 30 months or 18 months in addition to make a decision about what other countries you might want to actually apply this PCT application to. And in fact, some people will file a provisional and not file a US utility at all and file a PCT application. And then 18 months from that, we'll file the US application, because you can also file a US application, a utility, from a PCT. So you can use the PCT as kind of the holder for your utility application in the US. And the reason why a lot of people like this is because it allows time for investment, right? So when you file your patent application, oftentimes you're thinking, well, I don't want to spend all this money on this utility application. It's a lot of effort, it's a lot of money. Do I have investment in this idea? It's a new idea. It's interesting, but am I actually going to get the investment that I need to actually, spend the money on filing a patent application for this? Well, a PCT application will allow you to extend that time period before spending all that money on countries. I mean, we've had applications where the person wants to cover in 20 countries, right? And the cost for covering in 20 countries, just application filing fees itself, just from the governments of those 20 countries, could end up being, $100,000 or even more than that, depending on where you're going and if you're needing translations and things like that. So a PCT application leaves your options open without having to spend, thousands and thousands of dollars to cover or protect your invention. Now, as I mentioned, the PCT application, there's also something called a foreign application, right? So this can be a national stage entry. So we like to think we're taking the PCT and we're entering that into a country, right? You don't have to come, from a PCT. You could come directly, right? So you could file a US provisional, and then within 1 year, you could file an application in France or in Germany. But oftentimes, most applicants actually file the PCT first, and then they make their decision about where they want to go after that. And what countries you should decide? Well, you say, well, what countries do I want to cover? Well, it's really going to be a business decision, right? You're going to want to think about where business is actually likely and would be useful. We have clients sometimes say to us, oh, I want to cover as many countries as possible. Give me 50 countries. But that's just not probably worth it. There are a lot of countries where, filing a patent application is just not going to be make business sense, right? You're going to file somewhere and then you're never going to actually use that application in that country, or it's going to be really hard to enforce it, right? You might want to say, well, I want to, file an application in Chile, but the problem is that it may be really difficult for you to enforce that patent in Chile. It just doesn't make sense to actually file there. And so, if somebody makes your product in Chile and tries to import it into the US, there are ways to protect that if you have a US application from things being imported into the US. So it probably doesn't make any sense. Maybe the economy is just not good enough in those countries, or the business just doesn't make sense. So you really need to be very careful about deciding which foreign applications you want to file, because it can really be a huge monetary sink if you just go crazy and start filing in a lot of countries. Okay, so I already mentioned there's something called design patents, but I want to kind of mention a little bit more detail about it. It's unlike a utility application, it's 14 years from the grant date. So a utility application's time period is calculated from the filing date, where design patents are calculated from the grant date. So it's a little different. And they can often be used in combination with utility patents. So there may be something about the invention you want to protect, about the look, right? So maybe if it's software, it's about how the software looks, right? Like where the icons are located, things like that. Um, you can, if it's a medical device, you could protect, for example, the way the actual medical device looks, right? The kind of style aspect to it, the ornamentation. These things can be protected with design patents. It can be very powerful. Because maybe everyone in the market will know will identify your product based on its look. And, someone who's trying to copy you is going to try to copy that exact look that you make. So you can protect that with design patents. And I will just say that design patents are actually often easier to obtain. It's a lot cheaper process, it's quicker. So a lot of people will like to get design patents because it can be a good option, especially if utility patents are just something that's just too much money, or it's not, it's going to take a long time. Because I'm not sure I even mentioned this, but oftentimes utility patents will take up to 5 years to grant. Now, the average, I'd say, is probably 2 to 3 years. But it can be 5, 6 years to get a utility patent, and sometimes that's just a long time for people. Um, and that's, there's a lot of cost involved with getting utility patents, but it all is often spread over that time period. And there are ways to make it go quicker. You can file requests for expedited prosecution at the patent office, but that costs money, right? They call it a track one, and it may, for a small entity, it would be $2,000. For a normal entity, it'd be $4,000. So it's expensive to get things sped up at the patent office. So sometimes design patents could be a good option to look at. All right, so let's talk about the process. I kind of mentioned it before. This is the normal kind of process when you first come up with your idea. A lot of places you're going to be doing it through an institution, or maybe it would be for your own process internally. But either way, it's probably a good idea to generate something we call an invention disclosure form. So that's kind of where the very first kind of way of jotting down your idea, right? So you might think about, okay, well, who are the inventors of this? Because that's something you should think about at the beginning. A lot of times people don't think about that. They're working collaboratively with a lot of people. Well, who actually invented this? Like, who is the person that contributed to this? And I will mention that the inventors of a patent application may be very different than the authors of a paper, for example, right? So if you think about who the inventors of a patent application are, who conceived of the idea, not necessarily who went out and implemented it, right? So if you're talking about authorship of a paper, there may be a lot of people, in the lab that actually implemented something, even though none of it was their idea, and they'll be added as an author of a paper in some examples, not all. But it is important to remember that authorship of papers are not necessarily the same as inventorship. So when you're starting out your patent application process, it's good to generate your invention disclosure form, list the inventors, also list the ideas, and also list, what is kind of the state of the art. What are people doing now, and what are you doing different than that? And that can help kind of jog your memory and think about and organize your ideas for that patent application. Once you've got all that down, you often will file your provisional application, right? And it's always important to file your provisional application before there's a public disclosure of the material. So if you got, for example, your paper and it's going to be published, you want to get that provisional application on file before the publication of that material. Now, there are still ways in the US to protect in the US, even after there's been some public disclosure. So it's not an absolute bar where once it's disclosed, you can never get patent application filed, but that is the case for some other countries, right? So some countries like Europe, once it's publicly disclosed, you basically foreclose your ability to protect your idea. So you want to make sure that the best case is to have your provisional application filed before you make that public disclosure, whether it be like you're speaking or whether that be just like published somewhere. And then also it's a good idea when you're at the very beginning is to work on the assignment. So, this in the US, inventions are the ownership of invention is with the inventors, right? And if there are two inventors, they equally own the entire patent. So at the very beginning, you want to make sure you work out the ownership of this patent. Is this patent going to be assigned to an institution? Is it going to be assigned to a company? You want to try to work on these things at the very beginning of the application process and not later on, because later on you can have disputes, you can have issues. And so it's a good idea to make sure you have the correct inventors at the beginning and that you have decided who's going to own this patent, right? Because there are, famous examples of where you have an inventor show up later and sells, his portion of the patent to a competitor, and then all of a sudden that competitor has free rights to use the invention because they're a full owner over it, just like the other patent inventors. Okay, so within 1 year of your filing of your provisional application, you can file a PCT application, as I mentioned before. So you might say, well, okay, well, what does this look like? Well, you might have some new material. So one thing that I often will see is people will file their provisional application and then they'll keep working on their idea, right? And as they keep working on their idea, they might come up with some new material. And when you have new material, you need to make sure that you have a new assignment for that new material. And then within 30 to 31 months, you'll file your utility application. I also have this nice PCT timeline, which you can look at later in detail, that kind of shows what happens once you file your PCT application. I also just kind of want to talk about when you should talk to different people. So depending on the situation, right, you should make sure that you have all these things dealt with that I talked about, the provisional application, your IDF, your assignment, before you discuss things with potential investors, right? You also, if you're in an institution, you want to be discussing these things with your in-house and with patent attorneys before you actually get to the provisional application stage, because it's really useful to have the input from people early on in the process and not after you've already discussed with investors. Okay, I want to jump to talk about the reasons to file patent applications. So, you hear some people say, well, it's great, we have a patent application, but what's the use? Why are we spending money on patent applications? Well, the first way is investors often expect good patent protection. It's important for investors to protect their investment. They want to see that you're actually spending effort and early on in the process that you've protected your ideas, your intellectual property. Patent protection can also, for example, if you're working at a hospital, protection could generate revenue for the hospital, or even if it's for your company, it could result in a license that generates revenue source for your company. And the other idea is protecting by filing early. It protects against other filers. The worst idea that can happen, and this happens for a lot of our clients, I'd say, is they just want to protect themselves, right? They don't want to be out there spending a lot of effort and coming up with this great idea. Then someone else files a patent application and stops them from being able to go forward with their idea. So you want to, if you file early, you're going to protect yourself against others being able to obtain a patent. So remember, the first to file obtains a patent. And if others are arriving at the same idea around the same time, you want to make sure you're got yours filed so you don't have to worry about the idea being patented by someone else and you not being able to actually use it. Filing early, of course, protects against loss of rights, right? So if you As I kind of mentioned before, if you disclose something publicly, you could have a big problem because you might not actually, have your idea protected. Even if you have an NDA in place with someone, if someone leaks the material, like for example, you have an NDA and you're talking to someone, then they leak that material out into the public, you might have no option or no recourse. Of course, with the NDA, you would be able to have, contractually sue them, but that's not going to protect you as regard to, other third parties. So, as I mentioned before, the US has a grace period. So even if you disclose something, you have 1 year to file your application, but foreign countries, it's not necessarily the same thing. Um, also, on the reasons to file, provisional applications are cheap, right? They don't, as I said before, there's not a lot of, requirements about how you're doing it. So it's a lot cheaper. The patent office doesn't charge a lot of money for provisional applications, and they're not published if you don't actually file a utility. So if you have an idea, you can put it in a provisional, and then if you just leave it, and after 1 year you decide not to file a utility, it won't be published. It remains secret, and so it's a great option just to protect yourself. Um, you know, I would say a lot of our inventors that we work with will just file a provisional application because they think it could be useful, and sometimes they'll let that go after a year because they don't feel like the invention is fully developed and they still want to work on the idea. So you might as well file your application before you publicly disclose, and it really can't hurt you, and it is not often that expensive. As I kind of mentioned, and I like to mention this again, is that it may be really difficult to determine who invented something. So a lot of times I'll actually counsel inventors to file a provisional application with their idea first before they start collaborating with someone, because you don't want to later on have a dispute about who came up with something. They said, well, no, I came up with that. And like, no, it was me. And you can solve that by filing a provisional application before you start collaborating. And then anything you come up with afterwards, obviously, will be very clear about who came up with what, because you'll have that effective provisional application to provide that evidence, right? And you can use that in court too. You could, if you have a dispute about who came up with something, you could show, hey, I had a provisional application, I filed it before we even started working together. So protecting software. Now we're going to kind of get in, we've talked about the details. We're going to talk about some specific types of patents. And I think this is kind of useful and interesting. Scott's going to take over in a second after I get done with this, the software patents. But I think it's useful because it shows you there's so many different types of patent applications that it can be, right? You could protect, the typical thing you can think of a machine, right? You think I'm going to protect a machine with a patent, but you can also protect other things, right? There's a lot of things that are out there, inventions that could be protected with patents. So software is one of those things, right? So oftentimes, you'll come up with a medical device, and there's going to be, some hardware aspects of that medical device, but a lot of times there's a lot of software aspects, especially now. Most patents, software, medical devices also come with software, right? So there are types of inventions of software, and these could be algorithms, workflows, interfaces, but there's also some challenges when it comes to protecting software, right? And those are subject matter eligibility. You've maybe heard of it, 101, Alice, abstract ideas. These are the things that are difficult sometimes protecting software. And then, of course, sufficiency of disclosure, right? Have you described the software in enough detail that the patent office believes that you actually have possession of the invention? So if I talk about subject matter eligibility, because I think it's an important one to talk about, really, when you're thinking about your patent application and you're thinking about your software, you need to think, hey, do I have a technical improvement here? Has my software done something that has actually improved the product or provided a practical application? The USPTO is always providing updated guidelines in this. However, it can be a very difficult area, and it's become more difficult than it has in the past. You probably think about, years ago, people were obtaining these business method patents, right? So they think, a method of creating peanut butter and jelly, right? It was the famous kind of funny patents, and those are really gone on the wayside, right? The patent office has really cracked down, and things that can only be done mentally can be only done in your head. Instructions, maybe like playing a game. These are really difficult to obtain these days, and most of the time it needs to be some software that has some practical benefit, right? So I talked about sufficiency of disclosure. It's really important when you're thinking about patents with software that you have enough detail, right? You don't just write, my invention can be done with AI, right? You need to actually describe how the AI is implementing your invention, how it's actually providing a benefit, providing flow charts. These are the kind of things that actually provide you enough disclosure to have sufficiency of disclosure under 112. So now I've jumped through software. I'm going to jump over to Scott. Hopefully, I gave him enough time to talk about these next issues.
Yeah, we'll get through it. Okay, so now I'm going to talk about some areas, patenting some types of inventions that are sort of more traditionally a biotech or pharmaceutical kind of a perspective. The first is diagnostics. So similarly to with software, the landscape for diagnostics has changed a lot over the last 15 years. About 15 years ago, it was possible to patent what I'm calling here a diagnostic invention, where you associate a marker with a particular disease, for example, through basic research, and it was fairly straightforward then to file a patent application and get a patent issued that covered just a method where you detect the marker and you make an inference, for example, diagnosing someone with a particular disease. The law has sort of shifted a lot since then, so now it's nearly impossible to get a patent on something as broad as what I just described. But there's lots of other ways we can do it by focusing on particular aspects of the invention, particular tools or reagents that are used for the invention. So this slide just lists some of the types of inventions. So there's the target molecules. Often these are going to be polynucleotides or polypeptides. There's the inference, where you detect or don't detect the presence or absence of a marker, and then draw an inference about a disease state or a probability of developing a disease state from that. And finally, reagents. Those are going to be reagents that are tailored to use in a particular assay, and often because of the nature of a reagent where there's a feature in it that links it to the particular marker you're looking for example, and then also a more general component, which is something that doesn't occur naturally, and the two things don't occur together naturally. That often kind of gives you a hook, and it can be easier to patent things like that. Again, some of the challenges here are going to be subject matter eligibility, and in particular, well, in the next few slides, I'll hit on where that comes up. There's also sufficiency of disclosure, and then in one case, there's this issue of divided infringement. So I'll hit on that when we get there. Okay, so target molecules. This is going to be things like either a nucleic acid that is your marker, so you've either got a mutant form or a non-mutant form, or maybe you're looking for the presence of a protein. This could be diagnosing a disease, an infectious disease, for example. You're looking for the presence of a protein that's associated with a virus, for example. In this context, we again have this issue of subject matter eligibility. So here, with the shift in the law, if we go back 15 years or so, there was sort of a legal sleight of hand that allowed people to get patent protection for an isolated nucleic acid sequence. So this is a naturally occurring nucleic acid sequence, but if you say that you've isolated it, you show that you experimentally did isolate it in the sense that you had it in a container, you purified it, you could get patent protection for that. Since then, the law has changed, and simply isolating the sequence is no longer considered sufficient as a basis to allow you to get a monopoly over the use of that sequence. So the kinds of things that are important to be able to do now to try to protect an invention like that is to make a non-natural form of the sequence. And you can do things like if there's a usefulness to linking a non-naturally occurring molecule to the sequence or a substrate or something like that, you can try to then get patent protection for that form of the sequence. It's also important, though, in that case, to be able to demonstrate that there's a particular function that flows from the non-natural form. So it's become sort of more technically detailed and complex to tell when you will and will not be able to get patent protection for something like that. There's also this issue of sufficiency of disclosure. So if we go back in time when people were generating chemical entities that were then used as therapeutics, for example, it was relatively straightforward to demonstrate through synthesis of a few exemplary molecules that you were entitled to get a patent that covers many million different variations on those molecules. But then when nucleic acid type of inventions and recombinant proteins sort of came into play, the law sort of looked at that situation, and there was a rethinking of what was required in order to demonstrate the breadth of your invention. And so the law kind of evolved in that area, and now there's this requirement that you really rigorously correlate the particular structures that you're trying to cover with your patent with the particular functions that result from those structures. So for example, if you isolate a infectious disease, a virus that causes an infectious disease, and you identify a particular protein that's very important to the immune system recognizing the virus, it's hard to get a patent that covers every possible natural variant of that virus that might be out there because of this particular legal issue. So if you're working in this area, it's important to kind of be aware of these points. And this is something that makes it important to work with a patent attorney who sort of understands this and can help you identify a productive path to pursue. We can go to the next slide. Okay, this is the inferences. This is the sort of diagnosing invention where, again, where you look for the marker and then you draw an inference from the presence or absence of the marker. So here, the subject matter eligibility as the law has evolved in that area. As I mentioned earlier, it's made it very difficult to get the really broad invention that flows from the mere initial recognition that a marker is essentially encoding some useful information. So one of the areas that's left as a result of the legal cases that have analyzed the law in this area is to combine the diagnosing with the treatment. So if you imagine you're diagnosing a patient who's a particularly strong candidate to receive then a particular treatment for type of the disease that they have, you can craft a patent claim that will combine those two pieces. This, though, well, the law has kind of provided that as a way to avoid the more restrictive application of subject matter eligibility. But if this topic is relevant to what you do, what your company's doing, you need to be mindful of this issue of divided infringement. So just speaking at a broad level there, the issue is if your patent is going to allow you to stop the use of your invention, you have to be able to identify an entity that is infringing the patent, and then you could use the patent to stop them from doing it. But if you imagine a situation where one entity, a testing company, for example, is performing a test and transmitting the results to a doctor who then determines that a patient is a candidate to receive your therapeutic, and then the company that manufactures the therapeutic is selling the therapeutic, it could be that you have those two entities each practicing part of your patent, but no one entity is practicing both parts. So that can raise some complex issues that you need to address. And there are ways you can craft your patent in a way that makes it much more likely you'll be able to show that there's only one actor that's infringing the whole claim that you have in your patent. But again, it's important to sort of delve into the complexities of this with an attorney and figure out whether patent protection is the right path for you to go down or not for an invention like that. Okay, now reagents. This is a situation where maybe you have reagents that are tailored to the particular assay you're using to look for the presence or absence of the set of markers you've identified. And the reason why these can be particularly valuable to consider is that it's generally easier to design patent claims that will cover reagents that you're going to use in your assay, and to do so in a way that does not encompass or cover naturally occurring products. And that's important because it allows you to avoid this subject matter eligibility bar to getting patent protection. An example that's kind of related to this, I was just reading about the other day, is there's a company now that's designed a set of genetic tests that they are marketing and selling a service to be used for IVF embryos. So if IVF embryos are generated, they can extract a few cells from the IVF embryo and then amplify the genome of those cells, and then look for a whole long list of markers and generate probabilities that a person that develops from that embryo is going to have increased risks for various genetic-based diseases. So in that case, they've pursued patent protection to tools and methods of doing the amplification of the genome. That's sort of that early step. They could potentially pursue patent protection for very tailored reagents and methods of how they do then the assays. But the overall data set that they generate, where they're looking for the presence or absence of a lot of different markers and then correlating that with disease, that's going to be harder to patent. So in that case, it's going to be better. And with what they're doing is they're focusing on trade secret protection for the correlation part of that, and they're using reagents and tools that are specific to the method of performing their test as something that can be protected with patents. So it's kind of a dual approach that's useful there. Here it's also, with the reagents, the sufficiency of disclosure is also going to be an issue. But again, it may be easier there because you're tying something that's very easy to describe that's present in the reagent with a part of the reagent that is maybe broader and more often subject to the more rigorous rules for description. But when you put the two together, it can be the case that it's easier to convince the patent office that you've adequately described what you're trying to claim. And go to the next one. Okay, this is just reminding of the trade secret option for the diagnostic testing data and diagnostic testing, sort of the algorithm that's followed. And so here again, the reason why trade secret protection is worth considering is there's a few key points. One is as the law has evolved and it's made it more difficult to get broad inference-based patents to issue. That means, of course, we have to pivot and look at other ways to protect those kind of inventions. So trade secrets are really sort of tailored in a way that makes them particularly useful here, because often if you're developing a sophisticated test that is looking at multiple markers and making sophisticated inferences, the exact way that that's done will often evolve over time as more data gets generated and analysis of the data allows more sophisticated questions to be asked of it. The trade secret protection can kind of evolve right along the way because it's not based on disclosing a particular snapshot of what your invention is and then getting patent protection in exchange for that. So if you're implementing a trade secret strategy, then you can keep secret and therefore keep as a valuable asset to your organization that whole data set and ways of using it as they evolve. So that's an important thing to consider if you're working in this field. Okay, and then just to hit on biologics. So this is related to the markers earlier in the diagnostic context. It's sort of another area where the evolution of the subject matter eligibility and the disclosure requirements has become very important in recent years as it's sort of squeezed the scope of what we can patent, or these so-called biologic inventions. And here I'm thinking of things like engineered immunoglobulins, like humanized antibody therapeutics, vaccines, and cellular therapies, either stem cells or things like CAR T cells. And again, as the law has evolved, we see some of the similar issues, which is the subject matter eligibility is kind of squeezing what we can do, and sufficiency of disclosure is also acting in the same way. So if we compare things to the past, it was possible to get really broad patent claims earlier in the sort of product development lifecycle in the past. As these two requirements have evolved, that's become more difficult. So that in a sense can make it more challenging to protect the kind of inventions that come out of academic research that's sort of driven just by investigating disease processes. But at the same time, sort of the flip side is that just means that the value of patents from later inventions as the commercialization process is conducted has now, in a sense, gone up. So there's opportunity for early stage companies to add a bit of their own development work to the original idea and get more focused patent protection that will cover the kind of inventions that come out of that work. And this slide here summarizes, I actually kind of jumped the gun and hit on this a bit earlier. I think we more or less hit on this. The one thing I'll point out here is if you're working with cellular therapeutics, one challenge that's kind of unique with a cellular product is that often if you think of it, the target, if you define what your product is, sometimes a cellular therapeutic product, the characteristics of the product can change over time. So maybe you isolate a particular kind of stem cell and it has certain features when you just isolated it that are very similar to the features it had when it was in vivo just before you isolated it. But then over time, you maybe genetically manipulate it and you then create a product that's ready to be administered as a therapeutic. And during that process, the cells may have changed, and those changes kind of create a great opportunity to pursue patent protection. But at the same time, what I see typically is that there's not much effort put into defining those changes in a way that would help to get patent protection. For a combination of reasons, probably it's not actually strictly necessary. And also, the more that those changes did get defined, it maybe creates a higher regulatory barrier to getting the product approved to administer to patients. So if you put those two things together, you end up with a situation where there aren't a lot of angles to define that cellular therapeutic product in a way that distinguishes it from the natural product sufficiently to be able to get patent protection. So there again, trade secret is potentially helpful, but it's also really valuable to work with a patent attorney who can help you kind of come up with creative strategies to protect inventions like that. And then the sufficiency of a disclosure. This I more or less hit on earlier. I'll just add that method, if you're working with a biological product, the way the law has evolved, it's more challenging now than it was in the past to get broad patent protection to the product itself. But methods of using the product can be, it can be easier to get broader patent claims to things like that. So I think that's it. Yep. Thanks.
Thanks. I guess if anyone had any questions, please feel free.